This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to speak about why the 11th Circuit Court of Appeals has agreed to allow the retrial of Philip Esformes, a convicted felon whose conviction and sentence were commuted by President Trump while he was still in office, but that presidential commutation doesn't stop the retrial on cases where the jury had been hung and was unable to make a decision. So in United States of America versus Philip Esformes, the United States Court of Appeal for the 11th Circuit on January 6, 2023, dealt with a challenge of the convictions of healthcare fraud brought by Mr. Esformes that included convictions for illegal kickbacks and money laundering and the related restitution award and forfeiture judgment. After Esformes filed this appeal, President Trump commuted his sentence of imprisonment and rendered any challenge to it moot. In his remaining challenges, Esformes argued that his indictment should have been dismissed because of prosecutorial misconduct, that the district court erroneously admitted expert opinion testimony against him, that the admissible evidence against him was insufficient to sustain his convictions, and that the restitution award and forfeiture judgment should be vacated. Esformes had owned and operated the Esformes Network, several medical facilities in Miami-Dade County, Florida. The network included skilled nursing facilities, residential medical facilities that provided services performed by nurses such as physical therapy or the operation of sensitive medical devices. Medicare and Medicaid will pay for a stay at a skilled nursing facility only if the patient receives medical certification that the admission is necessary and if the patient spent at least 3 days at an acute care hospital immediately before admission. After a grand jury indicted 2 of his associates, Gabriel and Guillermo Delgado, Esformes entered into a joint defense agreement with the Delgados. The government later added a drug charge to Guillermo Delgado's indictment that threatened a significant higher term of imprisonment. Esformes then offered to pay a significant sum of money to Guillermo Delgado so that he could flee the United States and avoid prosecution in the United States. The Delgados, not trusting Esformes, signed a sealed plea agreement and began recording their conversations with Esformes and passed along to the government multiple recordings, including some that involved conversations between Esformes and his attorneys. The following year, an indictment charged that Esformes and others conspired to use the network to defraud Medicare and Medicaid of millions of dollars. The Federal Bureau of Investigation executed a search warrant on Esformes' Eden Garden Medical Facility to seize business records related to the healthcare fraud investigation of Esformes. The government knew beforehand that Norman Ginsburg, an Illinois licensed attorney who worked with Esformes, had an office at Eden Gardens, and a member of Esformes' defense team warned the agents that there were privileged materials at Eden Gardens. The government established a taint protocol to identify privileged documents found in the search and to keep the prosecution team from seeing them. It chose agents who were not otherwise involved in the investigation to conduct the search, but these measures for some reason failed. The district court concluded that the prosecutors committed misconduct, but rejected a finding of bad faith and dishonesty. At Esformes' 2-month trial, prosecutors presented 3 types of evidence material to this appeal. First, Esformes' co-conspirators, including Gabriel Delgado, testified about the conspiracy, its means, and their roles in it. Second, the prosecutors presented summary testimony from Michael Petrone, who identified various transactions in Esformes financial records as bribes, kickbacks, and efforts to conceal illegal proceeds. The jury convicted Esformes on 20 counts. The jury failed to reach a verdict with respect to the 6 remaining counts, and the government stated that it intends to retry Esformes on those counts. After Esformes filed his appeal, then-President Donald Trump commuted Esformes' term of imprisonment to a time served, but left intact and in effect the remaining 3-year term of supervised release with all its conditions, the unpaid balance of his restitution obligation, if any, and all other components of the sentence. The 11th Circuit, after a lengthy review, concluded, 1, that the presidential commutation rendered Esformes' appeal on his prison sentence moot, but does not otherwise affect his appeal. 2, the district court did not abuse its discretion when it declined to dismiss the indictment or to disqualify the prosecutors due to misconduct. 3, affirmed the admission of Dr. Sifu's expert opinion testimony. 4, affirmed the restitution amount as not clearly erroneous. 5, held that there was sufficient evidence for the jury to convict Esformes of money laundering, and that the forfeiture judgment based on money laundering was lawfully calculated. 6, the district court's restitution order was not clearly erroneous. There was plenty of evidence of actual loss to the government. Indeed, defrauding the government was the core of the Esformes network conspiracy. 7, the district court's forfeiture order was lawful because it is a federal crime to engage in transaction knowing that it is designed in whole or part to conceal or disguise the nature, the location, the source, the ownership, or the control of the proceeds of a specified unlawful activity. And when a defendant is found guilty of the federal money laundering, the district court shall order that the person forfeit to the United States any property, real or personal, involved in such offense, or any property traceable to such property. 8, legally sufficient evidence supported Esformes' money laundering convictions. 9, Esformes' sentence did not violate the Constitution. And 10, Esformes does not contest the $38.7 million calculation of the value of the property involved in his crimes, so any forfeiture under $77.4 million was presumptively constitutional, and Esformes offers no basis to rebut that presumption. Esformes will therefore be tried on the 6 counts, not the subject of the presidential commutation. In my opinion, health insurance fraud perpetrators who steal millions from U.S. government programs garner wealth beyond the normal health care providers' dreams. The wealth Esformes acquired was not earned. It was stolen. He was properly convicted on many counts and sentenced to prison. President Trump allowed him to get out of jail early, but refused, because he was so obviously guilty, to pardon him. Since the jury could not decide on 6 counts, and since the original verdict was proper, the government will be able to try him again on the 6 counts that were not proved in the first trial, and if found guilty, sentence him back into jail. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you wish, you can also subscribe to the blog and will be advised of each blog posting, usually 5 a week, sometimes more. You can also subscribe to these videos on rumble.com, where there's more than 600 videos, or on youtube.com, where there's even more videos. And subscribe to those videos so that you miss none. And if you found this video and the blog posting to be interesting or useful to you and your friends or colleagues, please tell them about it so that they can also subscribe. And if you're interested, you might also consider subscribing to my Locals channel and my Substack publications, where you can get additional information and detail for a very small fee. Thank you for your attention.